Okay. Now, first of all, as you can see our Bill of Rights, and you see I had to make the point that these are a bill of unalienable rights. This is probably the biggest key to the difference between the way we're taught about our rights today and the way that the founders originally thought it to be. Okay? Because they believed that Declaration of Independence, talking about those unalienable rights, that was what they were dealing with. They knew that these were unalienable rights. It's just not listed in the Bill of Rights, and that, I believe, was a flaw. They should have put it into the Bill of Rights itself, and these are a Bill of Unalienable Rights. Okay? But we've got to consider it as such. Now, to prove the point that they actually believed this, I quote this from United States versus Twin City Power, 1956. Okay? There's court cases out there, and here's the problem. Most people don't go out and do legal research. Most people don't know this stuff. When you've got a constitutional attorney out there, what do they focus on? They focus on those specific cases where they can actually point these things and they've gone through and they have not been overturned. They go through a process they call shepherdizing, okay? To say, okay, if this still stands or has it been changed and there's a new precedent, okay? This one here has not been changed. It has been shepherdized and it's still valid. It's still a landmark case that you can use as precedent. I'm going to read them out here real quick. The first 10 amendments to the Constitution, adopted as they were soon after the adoption of the Constitution, are in the nature of a Bill of Rights, and were adopted in order to quiet the apprehension of many that without some such declaration of rights the government would assume and might be held to possess the power to trespass upon the rights of persons and property, which by the Declaration of Independence were affirmed to be unalienable rights. United States versus Twin City Power. Okay? So even as recently as 1956, we're saying these are unalienable rights, and this is what they were intended to do, is keep the government from trespassing, infringing upon our rights. Okay? Several more. Inalienable rights, by definition. Rights which are not capable of being surrendered or transferred without the consent of one possessing such rights. Once again, government by consent, there's no way that someone can take away any right you have without you giving it away, signing it over, or, in worst case scenarios, what they call an adhesion contract. Now what that means is that it automatically assumes that once you go ahead and sign this document or whatever else, without it giving you full disclosure, you're just accepting it. Or consent by sign. Next one, things which are not in commerce as public roads or in their nature unalienable. Ouch. Things which are not in commerce, and such as public roads, are in their nature unalienable. This will touch on the 9th Amendment. If public roads are unalienable and can't be infringed, your right to travel, in effect, is infringible, it's an unalienable, then obviously they can't rule you in that area. Some things are unalienable in consequence of particular provisions in the law forbidding their sale or transfer as pensions granted by the government. The natural rights of life and liberty are unalienable. Okay, that's what you're born with. That's directly out of Boudier's Law Dictionary. Now, by the way, I told you, up until the Civil War was an aggression. The Blackstone commentaries on the English common law was used as the definition source for the Supreme Court. At the time of the Civil War, Bouvier became the new dictionary. Okay? So it still stands. Lastly, unalienable and capable of being alienated, that is, sold and transferred. Black's Law Dictionary, 6th edition, page 1523. Among these inalienable rights is pertaining to that great document is the right of men to pursue their happiness, which is meant the right to pursue any lawful business or vocation, by which is meant the right to, in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties, so as to give them their highest enjoyment. What does that mean? You have a right to work where you wish without the government's interference. Period. The common business and callings of life, the ordinary trades and pursuits, which are innocuous in themselves, have been followed in all communities from time immemorial, must therefore be free in this country to alike upon the same conditions. And I quote the last phrase, the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. So what does that mean? Yeah, the fruits of your labor are yours, and that is the source of any other form of property that you might acquire. So therefore, it's inviolable.
Property tax.
Payroll tax. Butchers Union versus Crescent City, and once again, this is from 1884, and it still stands. But how many times has it been heard by the state of the Supreme Court? Not once. They won't hear it. Especially since the 16th Amendment. The Due Process Clause protects the unalienable liberty recognized in the Declaration of Independence rather than the particular rights or privileges conferred by specific laws or regulations. Once again, even your right to due process, they're tying it directly to the Declaration of Independence as well. If the inmate, now this one I brought up for a couple of reasons, but let me go through this. If the inmate's protected liberty interests are no greater than the state chooses to allow, he is really little more than the slave described in the 19th century cases. Wow. So, in other words, even though someone might be incarcerated, they don't lose their rights. They don't lose their rights. I think it's clear that even the inmate retains an unalienable interest in liberty. Okay? Unalienable. At the very minimum, the right to be treated with dignity, which the Constitution may never ignore. Region versus Fano, 1976.
Now they get away with taking comedy for that other way.
Okay, now we're going to get to the Preamble of the Bill of Rights. Now, I've mentioned this previously. Scary thing, like I said, in most law books today, the Preamble of the Bill of Rights does not exist in those books. It has been removed. The largest producer of law books is Westlaw, or West Group. It is not to be found in any of those law books. There's a lot of speculation, so I'll give you the primary reason I think that it is. Okay? So this is my opinion. I've had it backed up by quite a few constitutional attorneys as well, but there is controversy here. If I'm going to quote a case site in a pleading, I'm going to defend myself in court using a case site. And I have to reference a law book and what page it's on and that kind of thing. If I could go in there and what I'm about to read here doesn't exist, I can't use it in a legal defense. Okay? The Preamble of the Bill of Rights is put in, and I will read. Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restricted clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. So what I've got in red in there points out a fact. These are amendments to the Constitution, so they are part of the Constitution. All right? They are a part of. And it says, in order to prevent misconstruction or abuse of its powers. Misconstruction means the changing of definition, the changing of meaning, and the abuse of powers is what was expected and what the anti-federalists were pushing back against, saying, wait a minute, there looks like there's too many holes in here where the national government can abuse its powers if we're granting it. Okay? So when it says the further declaratory and restrictive clauses, what are they talking about there? They're saying further, the remainder of the Constitution up to this point. Okay? Declaratory, just like our Declaration of Independence, is a declaration. It's a statement of fact. Hard and fast. There's nothing outside of it. You can't read the Declaration of Independence and kind of read other things into it. It says what it says, and that's what it means. That's what this preamble is talking about. Secondly, not only declaratory, but restrictive. Further declaratory and restrictive. So that means we're restraining that Constitution to exactly what it says. There are no implied powers. Okay? And these further amendments, these rights that we're going to have in our Bill of Rights, are restrictions against government. Prohibition. They're saying that these are absolute things that the government shall not infringe upon. Okay? These were added for one reason, or primary reason. Extending the ground of public confidence in the government. Because they had no confidence in the government whatsoever. They had more confidence in the Articles of Confederation because basically they could run themselves. You know, they could handle things locally. But in this, they had no confidence in it. Across the board. Remember, this Bill of Rights was required by a lot of these states before they would even ratify. Okay? Will best ensure the beneficent ends of this institution. This institution means the creation of the government, which in the Declaration of Independence it says the reason why we create government is to protect our rights. Okay? There so far.